name's Leona Bennett and I'm a solicitor here at Southern Waters Legal and head of the family law team. I'm here with Caitlin from my team, and we are continuing with some of our frequently asked questions that come across our desk, and we thought it would assist people by giving some answers. So one of the questions we get asked all of the time is, can I resolve my matter without having to go to court, or what options are available to me?
Definitely can resolve your matter without having to proceed to court. It's in fact something that the court does encourage the parties trying to engage in negotiation discussions prior to initiating proceedings. There's options available to you, so if we are able to just engage in negotiation discussions with the other parties, we might be able to formalise your matter by way of a binding financial agreement or an application for consent orders, which can then be filed in the Federal Circuit and Family Court and subject to a judicial registrar determining that it's just an equitable or it's in the best interest of the children. They can then subsequently make the orders.
That's completely right. One of the things we do at a first conference is I often draw this timeline on the board and I explain this 2.5-year process and say, if you start here and you finish here, here's a judge determining your matter, and it will cost an enormous amount of money and a large portion of your life will be consumed, potentially 2.5 years of getting to that resolution. Or down this other end of the timeline, you have the option to reach agreement with your partner. And you can formalise that by way of court orders, as Caitlin said, that you send into the court by way of consent orders, and they carry the same force and effect as if you let a judge make a decision for you down the end. But a very valid question then is, well, how do I get to an agreement without someone enforcing something upon me? I've been trying to talk to my partner, I put something, they put something, we're completely at odds as to what we think is fair, or both of our definitions of what is fair is different. So what type of options do people have if they've exhausted those discussions and they haven't reached agreement?
So one option that would be available to you is to engage in a mediation with the other party. There'd be an independent third-party mediator just there to give you both a bit of insight about what could be worst-case scenario if you were to initiate proceedings in court, how long that might be the case, the costs that you'd incur, but then also just give you both the option to discuss what you'd like and what they'd like, and then enable potentially for a resolution to be made between the two of you that's suitable to both.
Yeah, and I think it's where we see an enormous amount of success is in mediations, because often what happens when parties separate is one person has an idea of what they think is fair, the other has another idea of what they think is fair. Both parties getting legal advice might narrow those parameters because they then understand what the court might think is fair, and then having a mediator again narrow those options makes it a lot easier. We also often find that regrettably, in the course of dealing with proceedings, there can be a lot of letters and dialogue between parties, but sometimes just getting in a room and having those discussions and having them within a set period of time really allows you to nut out some of the issues in dispute and take control over your own destiny rather than letting someone else make a decision about what might happen insofar as it relates to the care of your children and or the division of your property. Probably one thing to mention, and it's worthy of note, is that there is an alternative way to resolve your matter where you certainly don't have to go to court at all. In fact, you contract out of going to court, and that is something that I'm really passionate about. It's called the process of collaborative law. Collaborative law is a really transparent and different way to approach a family law matter and a separation, and it's where the parties and their lawyers, importantly, contract not to go to court. So if I see a client and they decide with my assistance that collaborative law suits them, we all sign a contract with a coach and with their partner and their partner's lawyer that nobody will take the matter to court and that they won't threaten to go to court. And then we deal with their matter in a series of meetings. So instead of having letters between the respective lawyers, we might have 3 to 5 meetings where we meet and we try and deal with a lot of issues that are in dispute. Why it's really beneficial is it's transparent. So unlike if Caitlin and I are running the matter and we're writing letters to each other and explaining the law or taking very oppositional positions, in a collaborative process, I give my client the advice while their ex hears that advice. And then I might advise their ex as part of their process, and their ex's lawyer will talk to me about what they think the process is. So there's real transparency in the process, which is very, very different to what happens when you litigate a matter. So there absolutely is ways that you can resolve your matter without having to go to court, and we would highly recommend it. And I would suggest that probably 75 to 80% of the clients we see never set foot in a courtroom and really pride themselves on navigating the process without that need for litigation. So if we can be of any assistance in helping you with your matter, please don't hesitate to give us a call.